Welcome once again to Lehto's Law. Here's Steve Lehto.
I did a video about a week ago regarding the law in Texas that the state passed, saying that social media entities that are of a certain size must follow certain guidelines set down by the state of Texas. And if they don't follow those guidelines, then people in Texas can sue them and basically sue them into oblivion. And so a lot of people pointed out that if that law were to stand, it would cause one of two or three possible things to happen. One of which is simply that those social media entities might just say, okay, we're no longer going to do business in Texas and try to find some way to cut Texas out. Or they may just shut off a lot of the functionality of the sites. So for instance, YouTube, if it wanted to, could simply flip a switch and shut off all the comments on all of the videos. And what's weird about this is I talked about this in a general concept, and this is a very unusual law. The law proposed is unusual. Apparently there's a law similar to it that was attempted in Florida, but the point is that these are something relatively new, and they're because, of course, that social media, looking at the history of our country, is relatively new as well. So in Texas, a federal district court had struck the law down and said it was unconstitutional. The Court of Appeals reversed that without opinion. They simply just reversed it, which is unusual. The parties then filed an appeal to the U.S. Supreme Court and asked for immediate relief from that Circuit Court of Appeals. And the Supreme Court granted that. Now, interestingly, a lot of these types of rulings are simply an order saying we don't grant it or we do grant it. And quite often the Supreme Court will do that and send it back down for further proceedings. And then once there's proceedings in the lower court, those might get back up to the Supreme Court, who will then revisit the full-blown issue. But what we've got right now is this case has not been tried at any level because the parties in the district court in Texas simply filed an action to block the law. And the court issued a ruling preliminarily saying, yes, this law appears to be a violation of the Constitution on its face. So that court never quite, I don't think, got into the full-blown trial aspect of what they could have gone into. And more troubling was the Court of Appeals that issued the one-sentence order without explaining their rationale. And so the Supreme Court would have a hard time ruling on this on its merits, considering the merits never got hashed out below. But the Supreme Court did something quite interesting, and both Tim and Nathan sent me notes, and Tim said, by the way, Steve, I'm sure you've gotten this thousands of times, but just to make sure, and Tim was the first. I said, no, Tim, you're the first. Nathan was the second, and that was it. But the Supreme Court reversed the Circuit Court of Appeals and has now, in essence, caused the law to be blocked again. But with that reversal came an opinion from the dissenting justices. So the majority of 5 who voted in favor of spinning around the Circuit Court of Appeals, they just said, we're reversing it. The 4 in the dissent filed a dissent. So I'm going to read to you from the dissent. This is the Supreme Court of the United States, Net Choice LLC, doing business as Net Choice et al. Versus Ken Paxton, the AG of Texas. And Net Choice is it's an industry group that represents a bunch of different social media entities. The application to vacate the stay presented to Justice Alito and by him referred to the court is granted. The May 11th order of the United States Court of Appeals for the Fifth Circuit staying the district court's preliminary injunction is vacated. So that's the order. That's the order. And then it says Justice Alito with Thomas and Gorsuch and Kagan dissent from the grant of application to vacate the stay. Now, Kagan said she would deny the application on different grounds, but Alito, Thomas, and Gorsuch wrote a dissenting opinion. This application concerns issues of great importance that will plainly merit this court's review. So they think it's going to get there and they will review it. Social media platforms have transformed the way people communicate with each other and obtain news. At issue is a groundbreaking Texas law that addresses the power of dominant social media corporations to shape public discussion of the important issues of the day. And one question I have is this. If you were to have these rules and laws apply to these social media entities that have 50 million users, but not the ones that have less than 50 million, are you giving an unfair advantage to the competition? That's just one question. The law in question is HB 20. It regulates social media platforms that are open to the public that enable users to communicate with other users for the primary purpose of posting information, comments, messages, or images, and that have at least 50 million active users in the United States in a calendar month. Section 7 of the law prohibits these platforms from censoring users based on viewpoint. And Section 2 requires covered platforms to disclose certain information about their business practices, including an acceptable use policy and a biannual transparency report. These platforms must also establish procedures by which users can appeal a platform's decision to remove content posted by the user. And I believe the law says that if something gets removed, you can demand to know why, and if they don't tell you within 48 hours, you can sue them. Applicants are two trade associations that represent major social media platforms covered by the statute. They challenged the constitutionality of HB 20 in the United States District Court of the Western District of Texas, contending, among other things, that the law is facially unconstitutional under the First Amendment, and that court agreed, issuing a preliminary injunction. The United States Court of Appeals to the Fifth Circuit, after briefing and oral arguments, stayed the preliminary injunction. Applicants now ask this court to vacate that stay while the Fifth Circuit resolves the appeal of the underlying preliminary injunction, and the court grants that extraordinary relief. Now, again, in the dissent, this is Lehto writing, I cannot agree with the court's disposition. To be entitled to vacatur of the stay, that is to get the stay vacated, applicants must show, among other things, a substantial likelihood of success on the merits. Members of this court have argued that a determination regarding an applicant's likelihood of success must be made under existing law, and whether applicants are likely to succeed under existing law is quite unclear. The law before us is novel, as are applicants' business models. Applicants claim that Section 7 interferes with their exercise of editorial discretion, and they maintain that this interference violates their right not to disseminate speech generated by others. Under some circumstances, we have recognized the right of organizations to refuse to host the speech of others, but we have also rejected such claims in other circumstances. And they go through a couple examples there. It is not at all obvious how our existing precedents, which predate the age of the internet, should apply to large social media companies, but Texas argues that this law is permissible under our case law. First, Texas contends that Section 7 does not require social media platforms to host any particular message, but only to refrain from discrimination against a user's speech on the basis of viewpoint. And again, I know people are going to say, Steve, they don't have to shut off all the comments. They just have to not censor anybody based on viewpoint. Well, they can't censor anybody at all, because the second they censor anybody, someone's going to go, well, they censored me because of my viewpoint. I'm going to sue them. And they're going to go to court because they've made it so potentially lucrative to sue these companies. Why wouldn't you go to court? And in this respect, the statute may be a permissible attempt to prevent repression of the freedom of speech by private interests. Second, he's saying that your right to free speech might guarantee you the right to put it on venues run by other people. Texas also argues HB 20 applies only to platforms that hold themselves out as open to the public and as neutral forums to the speech of others. These representations suggest that the covered social media platforms, like the cable operators in another case we talked about, do not generally convey ideas or messages that they have endorsed. Third, since HB 20 is limited to companies with 50 million active users, Texas argues that the law applies to only those entities that possess some measure of common carrier-like market power, and this power gives them an opportunity to shut out disfavored speakers. And here's the thing. There are other platforms that you can go to. So there's YouTube, there's Vimeo, right? There are other platforms that compete with the ones that we're talking about. And some people are going to say, but Steve, if you want to get your message out, you got to get onto one of these platforms. Well, the thing about it is that if I get onto Twitter, by the way, I'm on Twitter. I got a couple thousand followers on Twitter, a couple thousand. So how hard do you think it would be for me to go onto another social media platform and get a couple thousand followers? And everybody's looking at it as if like, oh, I'm going to get on this platform, I'm going to have millions of followers, and then if I say something, they're going to throttle my speech. If anything, Texas argues, its arguments regarding the constitutionality of TU's disclosure requirements are even stronger. The state notes that we have upheld laws requiring businesses disclose purely factual and uncontroversial information about the terms under which their services will be available. If we were to agree with the applicant's arguments, the decision could have widespread implications with regard to other disclosures required by federal and state law. The procedural posture of this case also counsels against removing the stay. Applicants sought pre-enforcement review of the statute in federal courts, so it's not clear how state courts would interpret this statute if it were applied to applicants' businesses, nor has it been resolved which platforms are covered by the law. I reiterate that I have not formed a definitive view on the novel legal questions that arise from Texas's decision to address the changing social and economic conditions it perceives, but precisely because of that, I'm not comfortable intervening at this point in the proceedings. While I can understand the court's apparent desire to delay enforcement of HB 20 while the appeal is pending, the preliminary injunction entered by the district court was itself a significant intrusion on state sovereignty, and Texas should not be required to seek pre-clearance from the federal courts before its laws go into effect. The Court of Appeals, after briefing and oral argument, concluded that the district court's order should be stayed, and a decision on the merits can be expected in the near future. I would not disturb the Court of Appeals' informed judgment about applicants' entitlement to a stay. I respectfully dissent for these reasons. And so what he's getting at its most basic, is he's saying that to get an injunction such as this, or to get immediate relief such as this, you've got to come into court and say, look, we need you to step in and spin this around because when it's fully litigated, we're going to win. You show likelihood of success in the merits. That's one of the things they look at. And he's saying that the standard for the Supreme Court is that you can show a likelihood of success on the merits based on pre-existing case law. And he says, by its very nature, this is a unique case in that this has never been in front of us before, this sort of case. Therefore, there cannot be pre-existing case law upon which we can rely. Now, I'm not going to get heavily into this, but I'm sure many of you will have caught already the fact that this is a 5-4 opinion. So there's 5 justices who said, no, we're going to reverse that order from the appeals court. And there's 4 who said, we wouldn't do that. Here's why. And so if you ask those 5 why they did that, was there pre-existing case law, they're going to say, well, obviously not with respect to social media giants of 50 million users or more a month, but other issues that arise under First Amendment issues and the freedom of association and so on and so forth. So that's what's going on there. So as of right now, the law is put on hold and someone's got to litigate this. But the other point that Lehto made, and I'll make sure that you caught this as well, is that there's the state of Texas. State of Texas has its own court system, its own constitution, its own legal system. So there's state courts, and they come up to, I presume, a Texas Supreme Court. And so if a state passes a law, quite often it'll work its way through the state system before somebody says, okay, this raises issues that have got to go to the Supreme Court. Now, there are many other instances where this has happened, where someone has passed a law in a state and someone has immediately said, that right there violates the Constitution. I'm so certain of it, I'm going to go to federal court and get this taken care of because it's a federal question, because it's the U.S. Constitution. And Lehto is also saying that he would prefer to see it litigated in the state courts and then brought to the U.S. Supreme Court eventually. And I'm not sure I agree with that, only because if you'll recall, the punitive nature of this statute, and the statute says that if you are a victim of one of these things, you've got the right to sue the social media giant for all kinds of damages, punitive damages, and so much per instance, and also injunctive relief. And also the attorney fees doubled. So your attorney's going to get a windfall as well. And so if he wants to see this litigated in the state courts, you would see a flurry, you'd see an avalanche of litigation against these companies, and they'd have to defend a ton of it just to get it litigated in the state court so they can then take it over to the Supreme Court. And there are occasions where laws get passed that are so within the realm of what the Supreme Court could look at And this is, I believe, one of them. So I would disagree respectfully with Justice Alito. And that is because I believe that a person, a judge, or a panel of judges can read this statute and say, okay, we can see how this will play out. And there have been cases before of laws that were passed where the courts were not sure how something was going to play out. And it took some time for certain cases to get litigated and go up on appeal, come back down, go up on appeal, and have case law get made. And there are great examples of this in the realm of some federal statutes, for instance, I know of, where federal statutes got passed, and a lot of attorneys said, I wonder how that's going to play out. And as the courts start interpreting terms, they start doing this, and suddenly it kind of evolves in a way that makes sense. And the question here is, I think it's pretty clear here, that if you are one of these biggies, Facebook, YouTube, Twitter, and you do anything, remember, if somebody posts a comment on one of these sites and somehow it doesn't get promoted as well as somebody else's comment, they can claim, well, I didn't get promoted as well as somebody else, therefore I'm being throttled, therefore I've got the right to sue. You might say, Steve, that's crazy. No, it's not crazy. Because remember, all I've got to do is allege that it happened, and I can file the lawsuit. And now they've got to defend themselves and prove that that's not what happened. And so there's going to be a lot of litigation on this in the state courts if the law is allowed to go into operation. And I'm not sure if that's the best thing here. I think the best thing here would be for the district court, the federal district court that has it, to litigate it as best they can at that level and see what happens. So as of right now, the law is still on hold. We're talking about HB 20 in Texas, and that's because the district court blocked it. The Circuit Court of Appeals reversed that, and the Supreme Court of the United States reversed that. But there is not an opinion from the majority on this case. And as of right now, they've said it's probably coming up here and we probably will rule. So somewhere down the road, this will be in front of the U.S. Supreme Court. At that point, we'll get the final word on it. So there you go. That's the case of Net Choice versus Ken Paxton, et cetera, et cetera. And as I mentioned, sent to me by Tim and Nathan. And as a final note, I've got to mention, I was contacted by Nico, who told me that his dad's birthday is today. Dan in Massachusetts, who, by the way, spent his career in risk management. And if you're a Seinfeld fan, you know why that's an interesting thing to study. It might be on your resume for some reason, risk management. But Dan, I got to say happy birthday, my friend. You've got a great son. And if you have questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. We are most true to ourselves when we're about 9 or 10, so revisit that time in your life by taking up hobbies you enjoyed as a child.